Hi, I'm David Cantor with the law offices of David Michael Cantor. And today's topic is going to be the crime of public sexual indecency. Now, a lot of people get this confused with indecent exposure. The difference is it's not just exposing your genitalia, it's intentionally or knowingly engaging in a sex act with yourself or another, whether it's intercourse, oral, or masturbatory. And there is another person present and you're reckless whether a reasonable person would be offended in that particular situation. Okay, well, what does that mean? That means if you're having sex in your living room and the curtains are wide open and it's in a densely populated area, that could be a problem for public sexual indecency. Now, there's a difference. If you're having sex and your curtain's only an inch wide and somebody came up to your front door, then walked over and peeked through the curtains, they can't claim that you were reckless. So, there's a lot of factors that have to be looked at. The punishment on this type of charge, if the person who saw this, the victim, is 15 years of age or older, then the defendant only faces a Class 1 misdemeanor, which is anywhere from 0 days in jail up to 6 months in jail. If the alleged victim is 14 years of age or younger, then this is a Class 5 felony, and that could be probation with 0 days in jail up to a year in jail, or prison of up to 2.5 years in prison. Now, the defenses, first and foremost, is that a person was not acting recklessly. This could be anywhere from where the officer sneaks up while two people are at Lover's Lane and he surprises them with a flashlight looking in the car. It could be where the officer sneaks up in an adult bookstore and jumps around the corner while somebody's watching one of the videos in those booths and masturbating, things of that nature. Now, the reasonable person not offended in that situation, that would be the adult bookstore. You almost expect to see that in the adult bookstore. Or it'd be one of these clubs. They have these swingers clubs or bars where this is actually legal. You can't go into one of those and then claim, I can't believe I'm seeing people actually having sex out in the open, because a reasonable person would expect to see that in that particular situation. Lastly, we have entrapment defenses. This is where officers will go to certain public parks where gay men will frequent these parks, and they'll send the signals. It's called the foot tap. Well, they'll be tapping in the stall next to the guy, the other guy, or next to the urinal, and the one person will turn and face the other person and start masturbating. Well, that's expected if you're sending out these signals in those particular areas. And we've had a lot of defenses in this particular area, and we've had success pointing out that the police are basically targeting the gay community. Now, in regards to victories in these particular cases, if you go to our website and go to the victory sections, you'll see that we've had a lot of success in these types of charges. If you or a friend have been charged with this, go to our website, give us a call, come on in. We'll have a free initial consultation with you, and we'll go over your case with you from top to bottom for free.